social assistance, social security. Yeah. So we'll start with the 15th. Then start చేయమంటారు sir?
Yeah, start చేయండి sir.
Okay. So question 15 is basically welfare of the labor. This is basically from this question was asked twice, but this basically is from the labor one. I think last semester we have studied about this, which is
Yes.
from the Factories Act, where what is the conditions in which labor or the welfare of the labor is taken care in an organization. So section 42 to 50 defines the welfare of labor. So objective is to ensure that employees working in factories are provided with basic facilities essential for a dignified life. So in that context, one is what are these different sections which we have to remember. Section 42 only, which is basically washing facilities. Factories must provide clean and adequate washing facilities for men and women. And then facilities for storing and drying clothing. 43 section, which says that the clothes not worn during working hours, suitable places petal. And facilities for sitting, section 44, so that you avoid unnecessary fatigue. And the other one is first aid appliances, section 45. Adequate first aid boxes must be supplied for factories greater than 500. Ambulance room is mandatory. And canteens, section 46. Factories employing more than 250 employees must provide canteens with prescribed standards. Shelters, restrooms, and lunch rooms. Section 47. Factories with more than 150 workers must provide suitable shelters or restrooms. And then creech. So, excuse me, section 48, factories employing more than 30 women employees must provide creches for children under 6 years. More than 30 women employees unde creches undali. Welfare officers. Section 49, factories employing more than 500 workers must appoint welfare officers to ensure workers' well-being. Power to make rules, section 50. State governments must make rules to to supplement welfare schemes. So, in this context, there are two cases. One is at P.U.D.R. Versus Union of India. In this case, the Supreme Court declared that allowing workers to receive less than minimum wages, I think we already studied, it is considered as a forced labor. And then the reason we quoted this case is also because the judgment emphasized the provision of fair working conditions and healthy and safety and welfare measures are integral part to protecting workers' dignity. So giving these welfare measures are integral part of workers' dignity. That is what the Supreme Court has told in 1982. Okay, it interpreted labor welfare rights not merely as statutory entitlements but as constitutional mandates, strengthening the enforceability of welfare provisions under the law, like the Factories Act. The same thing with the second case, MC Mehta, State of Tamil Nadu, where the court has said that employment of children in match factories is basically health, safety, welfare protections of factory act are violated. The court also issued guidelines. Okay, strict compliances. So ఇందులో కూడా ఈ కేసులో కూడా what are all the health and welfare provisions you need to provide, like sitting, creaches, proper ventilation, safe working conditions. Okay, the case reaffirmed that state governments and employees must proactively enforce welfare rights and held that a failure to do so rights is in violation of fundamental rights under Article 21 and 24. So what is the essence of welfare provisions? Welfares are mandatory. They promote human dignity, and factories employing higher number of workers have higher obligations. So state governments can strengthen welfare rules beyond minimum standards. So this question was asked from Factories Act 1948. So we have written all the sections and the relevant cases and what for this question. Any questions, sir?
No, sir. This is the only question till now. అంటే మన లాంగ్ క్వశ్చన్స్ నుంచి కాకుండా కొద్దిగా డివేట్ అయింది ఒకటే క్వశ్చన్.
Debate. And sir, what they do is, what I have seen is, ఒక question usually labor to labor one unte, sometimes they are asking from labor one. అంటే చాయిస్ లో వదిలేస్తారు. అంటే ఇప్పుడు మొన్న క్లాస్ లో కూడా చెప్తున్నారు కదా, మీకు అన్ని గుర్తుండాలి, మీరు అన్ని చదువుకోవాలి, ఆల్ దీస్. సో దిస్ వాజ్ యాక్చువల్లీ ఆస్క్డ్ ట్వైస్. Welfare of labor అని. So better to study and keep it. So And the other one is set on and set off. I think this question was also asked twice. So basically, the legal framework entered in the new section, which is Code of Wages, Section 35, Section 36, Section 15, and Schedule 4 of the Code of Wages, which was earlier under Section 15, talk about set off and set on. These provisions are designed to smoothen bonus payments and clinical companies' financial performance across multiple years. So I think we have studied this.
Yes, sir. As part of bonus to set off.
The first time when the set on and set off parameters were actually given were in that Kamani Metals case.
Yes, yes.
Kamani Metals case law, they have given guidelines on that set on and set off. I think we have studied in the earlier part B and part A. Exact question గుర్తురాట్లేదు. So set on in India when the allocable surplus. So you have to remember this. Then you have to say allocable surplus. Okay. You cannot say available surplus.
Available surplus, yes, yes. మీరు చెప్పారు మొన్న మీరే చెప్పారు.
అదే సార్ ఇందా allocable surplus గురించి నేర్చుకున్నాం కదా. When the allocable surplus in the year exceeds the minimum bonus payable, the excess amount is carried forward to be used for paying bonuses in the next 4 accounting years. Okay. When there is no allocable surplus or shortfall in the year, the amount can be adjusted and set off against future years surpluses within the next 4 years. So ఈ 4 years కి ఒక అకౌంటింగ్ సిస్టమ్ నడుపుతారు సార్, అండ్ దెన్ ఇట్ ఈస్ రీసెట్ టు 0, 0. సో వాట్ ఎవర్ ఎక్సెస్ ఆర్ అంటే సెట్ ఆన్ ఆర్ సెట్ ఆఫ్ ఎక్సెసెస్ ఉన్నాయనుకోండి, దట్ ద కంపెనీ విల్ హ్యావ్ టు టేక్ అవుట్ ఇన్ ద ఎక్స్పెన్సెస్ అనమాట.
క్యారీ ఫార్వర్డ్ అవుతుంది. సెట్ ఆన్ అయితే క్యారీ ఫార్వర్డ్, సెట్ ఆఫ్ అయినా స్టిల్ ఇట్ విల్ బి క్యారీ ఫార్వర్డ్.
సో ఫర్ ఎగ్జాంపుల్ 4 years తర్వాత -1 lakh ఉందనుకోండి, అది కంపెనీ హ్యాస్ టు అబ్జార్బ్. ఆర్ 4 years తర్వాత +1 lakh ఉందనుకోండి, ద కంపెనీ విల్ అబ్జార్బ్. అండ్ సెట్ ఆన్ సెట్ ఆఫ్ 0, 0 అయిపోతాయి అన్నమాట 5th year నుంచి.
నెక్స్ట్ ఇయర్ లో అడ్జస్ట్ చేస్తారు.
కరెక్ట్. సో దే అడ్జస్ట్ ఫర్ ఓన్లీ 4 years.
Up to 4 years, yeah.
For the next 4 years. That's what it is saying. So allocable surplus, the portion of profits earmarked for bonus distribution, calculated as 60% of banking companies, 67% available. This I think we have studied in the last. If in any year allocable surplus exceeds the amount required for paying maximum bonus, and what is allocable surplus? Maximum 20% and maximum 20% ఇవ్వచ్చు కదా సార్, minimum 8.33. If it exceeds that amount, then there is an available surplus for the bonus payment, which can be used in subsequent years. So it can be set off for up to 4 years. So set off is also same. If allocable surplus is insufficient to pay minimum bonus, that shortfall is carried forward and set off against future surpluses within the next 4 years. So same thing, I think we're repeating carry forward rules, set off and set off for a maximum 4 consecutive accounting years. Purpose ఏంటంటే ensures minimum bonus is paid even in bad years and using previous surpluses, prevents excessive payout in good years and allowing buffering surplus, encourages long-term balance and compliance. This creates a rolling reserve system that promotes fairness and economic stability for both employer and the employee. So ఇక్కడ ఏంటంటే మనం the relevant case laws law, we can write that Kamani Metals. And there are 2 other cases also which I have quoted, which is basically the Jalan Trading Company versus Miller Mazdoor Sabha, where the Supreme Court upheld the constitutionality of the payment of bonus and set on and certain provisions were considered. It noted that the scheme provides equal opportunities for both employees and employees during variable profits. The mechanism of carry forward surplus and deducting deficiencies in years when the company operates at loss provides a rational means of equitable setting of the rights to the bonus over a number of accounting years. So basically, I think they challenged the set on and set off bonuses, where the Supreme Court said, no, it is a good scheme that provides equal opportunity and it should be continued. The second one was Workmen of Meenakshi Mills versus Meenakshi Mills. This case concerned the proper calculation of bonus and carry forwarded. The court held that although the schedule has to be compliant, the schedule does not in any way change the fact that you can take into account the set off and set off from previous 4 accounting periods. The rule clarified that employees cannot invent a set off or simply ignore balances from previous years, and the employee's right to bonus must be calculated and accounted for so that the both employees and employees can see in employees' books. So basically, in this, I think the company created its own set of policies, where the court said that you cannot do that, and it also said that 4 accounting periods you have to carry forward the accrued or deficit totals. Sorry, Pawan garu meedo చెప్తున్నారు.
అంటే బేసిక్గా ట్రాన్స్పరెన్సీ లేదు అని చెప్పి దిస్ కేసులో వాళ్ళు దే నీడ్ టు కీప్ ఇట్ ట్రాన్స్పరెంట్ టు ఎంప్లాయీస్ ఆల్సో ఫర్ ద బుక్స్ అండ్ క్యాలిక్యులేషన్ హ్యాస్ టు బి ట్రాన్స్పరెంట్ అని చెప్పి.
కరెక్ట్. సో ఇందులో ఏంటంటే ఒక సింపుల్ ఎగ్జాంపుల్, అలొకేబుల్ సర్ప్లస్ 10 lakhs ఉంది, బోనస్ 7 lakhs అయితే you got an excess of 3 lakhs which is basically it is set on. Next year 5 lakhs అయింది, 7 lakhs అయింది, and deficit is 2 lakhs which is set off. So just some example మన ఎగ్జామ్ లో రాయడానికి.
బ్యూటిఫుల్ సార్, చాలా బాగా సార్ ఇదైతే ఎగ్జాంపుల్
క్రియేటెడ్ ఇట్ సో దట్ ఏదో సార్ ఇంకా ఫిల్ చేయాలి కదా పేపర్లో. సో అందుకని చేశాను సార్. The set-off and set-off mechanism under the Code of Wages reflects a progressive approach to bonus distribution. It smoothens fluctuations, protects both employer and employee interests, and ensures legally consistent bonus practices over time. Judicial pronouncements. So sorry, Pawan, did you?
No, nothing, sir. Please carry.
Okay. Judicial pronouncements like Jalan Trading and Meenakshi Mills reaffirm the system's constitutionality and accounting rigor, making it a vital tool in labor welfare regulation. So ikkada endante set on set off ki you can also quote the Kamani thing along with Jalan Trading and Meenakshi Mills. So again, question 17 is from the first level, third semester in IRC code, Industrial Relationship Code 2020. ఇది బేసికలీ లాస్ట్ ఇయర్ ఎగ్జామ్లోనే అడిగారు. ఇంట్రెస్టింగ్ ఐఆర్సి కోడ్ గురించి లేబర్ టు దాంట్లో అడిగారు వాళ్ళు. సో ఐ థింక్ లాస్ట్ సెమిస్టర్ వీ రెడ్ ఆల్ దీస్. ద ఇండస్ట్రియల్ రిలేషన్ కోడ్ 2020 consolidates and simplify 3 major labor laws, which was the Industrial Dispute Act 1947, the Trade Unions Act 1926, and the Industrial Employment Standing Orders Act 1946. So you have to talk about the Industrial Relationship Code, and this I think we have taken it from the last year notes only. So what are the aims of the Industrial Relationship Code? One, ensuring industrial peace and harmony, so that the code remains a mechanism like reconciliation, arbitration, and education to resolve disputes. So if a factory worker demands a wage increase, the dispute can be resolved through conciliation of officer before escalating to the tribunal. Simplifying and codifying labor laws, merge multiple labor laws into a single code for easier compliance, and protection of workers' rights, safeguard employees under unfair termination, discrimination, arbitrary actions without notice. Regulation of strikes and lockouts requires a 60-day notice ivali, and before a strike, and public utility studies and large industrial establishments. Encouraging collective bargaining, so ensures that trade unions represent at least 51% of the workers in an establishment got official recognition. And ensuring fair and transparent employment conditions, mandates clear rules including standing order, disciplinary actions, and grievance handling in industrial establishments. And then facilitating ease of doing business, simplifies compliance for business while protecting workers' rights. Protection of national economy from industrial disputes, prevent sudden strikes or lockouts that could impact critical services and economic growth. So these are why the aims of the Industrial Relations Code. And then the objectives, and what are the objectives is definition and resolution of industrial disputes, regulation of layoffs, so trenches and closures, so large industrial establishment 300 plus workers and all that require prior government approval, and ensuring fair compensation for workers. అంటే రిట్రెచ్మెంట్ కాంపెన్సేషన్ ఈక్వల్ టు 15 days. అంటే రిట్రెచ్మెంట్ పని లేదని తీసేసినప్పుడు 15 days ఇవ్వాలి ఫర్ ఎవ్రీ కంప్లీటెడ్ ఇయర్ ఆఫ్ కంటిన్యూస్ సర్వీస్ ఆర్ పార్ట్ దేర్ ఆఫ్ ఇన్ ఎక్సెస్ ఆఫ్ 6 months. Okay, and then streamlining dispute resolution mechanisms, grievance redressal, reconciliation officers, industrial tribunals are all important. And then regulating strikes, encouraging worker-employee cooperation, and protecting against unfair labor practices. Authorities under Industrial Relation Code in Conciliation Officer, Industrial Tribunals, and National Industrial Tribunals. And then I think we also read some key provisions. Section 2Q, industrial disputes, so 62 was notice for strikes, so 14.3, recognition of trade unions, so 4 was grievances, section 70 was compensation for retrenchment, 51 industrial tribunals, and then national industrial tribunals for 52. So relevant cases ఏంటంటే Santosh Gupta was a state of Patiala. I think this is also a case which we read last year. A temporary employer State Bank of Patiala were retrenched without following the conditions under section 25F of industrial disputes, which mandates notice and compensation. The bank claimed that she was not a workman under the act. Supreme Court held she was indeed a workman and that non-compliance made the retrenchment invalid. The court emphasized that ID Act's purpose is to protect job security, and any deviation from ID and industrial disputes from mandatory retrenchment procedure renders the action unlawful. Second one is Bharat Iron Works versus Balubai Patel. The employer dismissed a workman for misconduct after a domestic injury. The punishment was challenged as harsh. Supreme Court acknowledges the employer's right to take disciplinary action, but ruled that punishment must be proportionate to the misconduct. The court stressed that industrial education must align with principles of fair play and equity. The balance must be struck between management's authority and workers' rights, making proportionality of punishment a crucial test in industrial disputes. So this is what it is, and I think this is the long answer which we have posted here, Industrial Relationship Code. But I am assuming that every year there will be one question which will come from Labor Notes 1 only.
Yes.
That is a pattern they're following. Maybe you can leave it in the choice, or you can just answer it if you want.
Correct. Yeah.
And last year అయితే రెండు అడిగారు. ఒకటి they asked about this industrial relationship code, and another question was basically dissolution of trade union. అంటే maybe cut and paste మర్చిపోయారు. So they asked two questions. So basically, dissolution of trade union. Dissolution of trade union refers to the process by which a registered trade union ceases to exist, either voluntarily by its members or compulsorily through legal orders. This process involves setting financial obligation, notifying authority, and ensuring proper distribution of funds. So basically, dissolution ఎట్లా చేస్తారు అంటే one voluntary dissolution అందరూ కలిసి చేయాలి. But in this, if the majority of members agree to dissolve, it is due to declining membership, then union can be legally dissolved. Next, to notice to registrar, and then you have to give a notice to registrar with a specific 14-day period signed by trade union's president. The third is distribution of funds. The assets and funds of the dissolved trade union must be distributed in accordance with the constitution. No specific rule exists. Funds should be distributed equally. Steel plant union had 10 lakhs in funds. Among members, distribute JSS. Registrar's role. Registrar verifies dissolution has been conducted lawfully and removes the union name from its official register. Failure to notify. Failure is if the required notice is not submitted, the trade union continues to be recognized legally and remains responsible for compliance with labor laws. And then what are the grounds for resolution? And lack of membership, financial difficulties, completion of objectives. A union formed for a specific purpose may dissolve once the objective is achieved. Internal disputes kuda, and frequent conflicts, mismanagement, leadership issues may lead to voluntary dissolution. Legal action. If a union is found to be involved in unlawful acts, the government can order its dissolution. Process of dissolution. One, resolution of members, settlement to distribution of assets, and filing with the registrar. And simple case, Madras High Court was Registrar of Unions. The court ruled that trade union must follow due process, ensure fair distribution of funds before dissolution of to prevent financial disputes. So, court case is not where they said that you have to first distribute whatever money is pending in the union equally and then only close it. Consequences of dissolution is one, loss of legal protection, no legal recognition, closure of pending disputes, and key changes under Industrial Dispute Act. What did the new act do is streamlining process of dissolution, stronger oversight by the registrar, and mandatory compliance with financial transparency. Dissolution of the trade union is a significant step that must be carried out in compliance with legal procedures. Proper notification, settlement of liability, distribution of funds are essential to prevent legal disputes and ensure fairness to members. The IRC 2020 ensures a more transparent and accountable dissolution process. Okay, sir?
Yes, right.
Yeah. So 2 questions from last year notes,
Yeah.
17 and 18. Sir, 19 में चौतरा?
చదువుతాను సార్.
Okay, thanks.
Notional Extension, Employees Compensation Act 1943. This is not repeated. So from here onwards, మన own questions.
లేదు సార్, యాక్చువల్లీ ఇది ఐ థింక్ అరేంజ్మెంట్ లో కొంచెం
No
రాంగ్
repeat. No repeat. Might be no repeat. Only single time.
యాక్చువల్లీ నో రిపీట్ లాస్ట్ లో వస్తాయి. ఇది కొంచెం మిస్ అయింది సార్, సారీ. షుడ్ బి క్వశ్చన్ 37, 30. ఎందుకంటే దీని తర్వాత 1 టైం అన్ని ఉన్నాయి మళ్ళీ.
నెక్స్ట్ క్వశ్చన్ 20 1 టైం. రైట్
37 దాకా ఉన్నాయి 1. సో ఐ థింక్ దిస్ షుడ్ హావ్ బీన్ ఇన్ ద అరేంజ్మెంట్ లో ప్రాబ్లం వచ్చింది సార్, సారీ.
ఓకే, లెట్ us continue.
యా.
Definition. Notional extension, and with this we are again back into our syllabus. Employee Compensation Act 1923. Definition: the concept of notional extension is the legal presumption that an employee is in the course of employment even when the employee is physically off the employer's premises or he is outside regular working hours. So it is a practical legal fiction to ensure liability for compensation is not denied on technical points of time and place, where there is a close and essential connection between the act that caused the injury and the employer's employment. It extends both the geographical and the time limits of the workplace. And it means, example, వాళ్ళ ప్రెమిసెస్ లోనే ఉండకుండా బయట ఉన్నా కూడా విత్ ఇన్ వర్కింగ్ అవర్స్ ఆన్ ద వర్క్ అది డిసైడ్ చేయడానికి this notional extension legal in specific legalities it works. Legal framework arising out of and in the course of employment, an entitlement to a claim for compensation under ECA is triggered by an injury arising out of and in the course of employment. The phrase arising out of and in the course of employment has 2 limbs. Arising out of employment, this means that there was a casual link between the injury and the employment. The injury must arise from a risk which is incidental to the nature of the employment. The term in the course of employment is about time, location, and circumstances of the accident. The doctrine of notional extension most significantly expands the link as it determines that an employee is in the course of employment where they are in place that is not required to be within the strict limit of the employer's premises of time of work. So basically, this is talking about when there is a compensation is because of injury and the arise అయినప్పుడు to decide whether the employee is within the premises and while doing the business అన్న దానికి. So sometimes, example, ఇప్పుడు may not be the factory, some offices, ఏదో వర్క్ పైన ఆఫీస్ వర్క్ పైన బ్యాంక్కి వెళ్ళేటప్పుడు ఏమైనా అయితే those kind of things basically. The spirit of notional extension is to capture those periods and places known as interstitial work, which are closely connected to the employee actual work and duties, and bring them into the fold of compensation, because the duties of the employee don't actually begin and stop at the gates of factory or the exact clock and time. So use of principle and circumstances. In various circumstances, courts have developed a number of tests to apply principle of notional extension. Fixed point test route. This has been described as the employment starts when the employee arrives at the place of access to the workplace, fixed gate or entry point. So and continues until the employee leaves. In an accident occurring in the added ambits of a variety of situations or in fixed and specified route to form work, especially if compelled or made available by the employer, would have probably satisfied notional exception. This typically within the gates. Employer control and transport, special duty or direction. If an employee is performing a special duty or traveling at the employee's direction and sustains an injury either off premises or outside the work hours, it may be compensable. Proximity. Accidents occurring just outside the factory gate or in the immediate vicinity of the workplace that have casual connection to entering or leaving work also tend to fall under notional extension. There are, however, limits to the application. There is always required to be a reasonable nexus between the accident and the work in all scenarios, and there is a threshold where merely traveling to and from work in an ordinary sense in on one's own violation and means is not compensable unless one of the specific extent situation applies. ఇది మీరు అన్నట్టుగా అంటే ఫ్యాక్టరీకి వెళ్తున్నప్పుడు వాళ్ళ పాపని ఏదో డ్రాప్ చేసి వేరే డిఫరెంట్ రూట్లో వెళ్తున్నారు, బట్ విత్ ఇన్ ఫ్యాక్టరీ విసినిటీలోకి వచ్చినప్పుడు ఇట్ కమ్స్ అండర్ దట్ సార్. ఎగ్జాక్ట్లీ
కరెక్ట్ సార్, కరెక్ట్.
Relevant cases: Saurashtra salt manufacturing versus Bai Valu Raja. This case is very notable in that very solidly endorsed the notional extension doctrine. Actually, this is an important case too when notional extension comes, because this is the one created notional extension doctrine. The Supreme Court stated in the course of employment was not tied to the actual hours of work or the immediacy of the whether the court explained that an accident would be deemed to be in the course of employment when the accident occurs while the employee is still within the territorial ambient of the employer premises or the usual or permitted means of entry and egress. The case developed the law that recognize the employer's liability for accidents that take place very close to the working environment. So this talks about actually the doctrine why notional extension is developed.
కరెక్ట్. అంటే కొన్ని ఫ్యాక్ట్స్ రాయలేదు అక్కడ. బేసికలీ ద కేస్ ఇన్వాల్వ్డ్ a boat accident. Actually several workmen were drowned while traveling to that salt works అన్నమాట. సో అప్పుడు ఏంటంటే ఆ డ్రౌన్ అయిన వాళ్ళు కంపెనీ కాంపెన్సేషన్ ఇవ్వాలా లేదా అనే దాని మీద ద ఎంటైర్ ప్రిమైస్ వెంట్. సో బేసికలీ ద సుప్రీం కోర్ట్ వాట్ ఇట్ డిడ్ ఈస్ లోవర్ కోర్ట్స్ డెసిషన్స్ ఇచ్చేసి saying that the accident did not occur within the scope of employment and workmen were not yet at the employee's premises or engaged in any work related activity at that time అని lower court order ఇచ్చింది. then supreme court దాన్ని రివర్స్ చేసింది అన్నమాట.
వాళ్ళు ఆల్రెడీ అంటే వర్క్ కోసమే వస్తున్నారు కాబట్టి ఆ టైంలో డ్రౌన్ అయ్యారు.
కరెక్ట్. సో ఈవెన్ దో వాళ్ళు అందరూ వస్తున్నారు, సో ఇట్ సెడ్ దట్ ఇట్ ఈస్ the court explained that the accident would be deemed in the course of employment when the accident occurs while the employee is still within the territorial ambient of the employee's premises. అంటే వాళ్ళు సార్ బోట్ రైడ్ ఓన్లీ ఫర్ సాల్ట్ దానికే వస్తున్నారు కదా.
అంతే అంతే. కరెక్ట్ కరెక్ట్. వేరే ఇట్స్ నాట్ లైక్ మనం అనుకున్నట్టు వేరే డిఫరెంట్
వేరే వాళ్ళ స్కూల్కి వెళ్ళి అలా ఫిషింగ్ పోవట్లే కదా. సో దాన్ని ఇంటర్ప్రిట్ చేసి లేదు ఇట్ ఈస్ కన్సిడర్డ్ విత్ ఇన్ ద టెరిటరీ ఆఫ్ ద ఎంప్లాయర్ అని ఇచ్చింది అనమాట.
వీళ్ళు దీనికోసమే వస్తున్నారు అంతే.
సో ఈ కేసులో నోషనల్ ఎక్స్టెన్షన్ డాక్ట్రైన్ ఎలా వర్క్ అవుతుందో సుప్రీం కోర్ట్ వాళ్ళు ఈ కేసు కొంచెం ఎక్స్ప్లెయిన్ చేశారు. టెరిటోరియల్ అంబియంట్ అని ఒక బయట నుంచి వర్క్ వస్తున్నాయి, ఎందుకంటే యూజువల్ గా వర్క్ వస్తున్నప్పుడు చాలా కేసుల్లో దే హావ్ నాట్ గివెన్, బట్ దిస్ వాజ్ అ కేస్ వేర్ దే గేవ్.
వెరీ సాలిడ్లీ ఎండోర్స్ ద నోషనల్ ఎక్స్టెన్షన్ డాక్ట్రైన్ అని హైలైట్ కూడా చేశారు. move to the
Yeah,
next
okay, sir. Sorry, go
case.
ahead.
General Manager, Best Undertaking, Bombay versus Agnes. This case was important to address going to and coming from rule associated with notional extension. The Supreme Court articulated that even though an employee usually begins their employment only upon reaching the workplace and ceases to be on duty once they leave, there are exceptions to this normalism. The court ruled that if an employee was given transportation to travel for work purpose, or the employee was obliged by contract to travel in a certain way or use a particular route, an injury while traveling under those circumstances would be treated as in the course of employment. This finding emphasized the test is not whether an employee was physically present at work, but whether the employee was engaged in travel which was incidental to employment, either by an express or implied term of their contract of employment or by nature of the duty. So this looks more like ఇప్పుడు ఐటీ ఎంప్లాయీస్ కి క్యాబ్స్ ప్రొవైడ్ చేస్తారు చూడండి, looks similar to that. So because they are coming and going for the work, even though they are not doing within the premises or not occupied with their duty, but still they are engaged in the work.
ఇందులో ఏంటంటే ఇంట్రెస్టింగ్లీ ద ఆర్గ్యుమెంట్ వాజ్ వాట్ దే ఆర్ సేయింగ్ ఇస్ వర్క్ కోసం వస్తున్నప్పుడు ఇవ్వచ్చు, కానీ వర్క్ అయిపోయి వెళ్ళిపోతున్నాడు కదా, మా బస్ అయినా వర్క్ అయిపోయి వెళ్ళిపోతున్నాడు కాబట్టి మాకు వర్క్ అయిపోయింది కాబట్టి మాకు సంబంధం లేదు. సో ద కేస్ అడ్రస్ ద సింపుల్ ఇంపార్టెంట్ ఇష్యూ గోయింగ్ ఆన్ అండ్ కమింగ్ ఫ్రమ్.
Yes.
Rule in the it doesn't matter. The court said it doesn't matter, bro. That is your vehicle, and you are forcing that person to use the company vehicle.
Right.
So you are saying that the employee was obligated to travel in a certain way or use a particular route, and therefore you are culpable and you should be paying.
Right. Yeah.
So the emphasis is on that going to and coming from. You have to remember that he was going away from the organization after work.
After work is going to home. అంటే ఇన్ సింపుల్ వే కెన్ వి టేక్, ఇప్పుడు నార్మల్ ఐటీ ఎంప్లాయీస్ క్యాబ్ తీసుకుంటే డైరెక్ట్ వాళ్ళ ఇంటికి కాకుండా మధ్యలో మీకు క్యాబ్ డ్రాప్ చేసుకుంటూ వెళ్తారు కదా.
అవును, కరెక్ట్. సో యు ఆర్ ఫోర్సింగ్
because he is obliged to go through that certain route, particular route.
Correct. So వాళ్ళకి ఏమైనా అయితే కంపెనీ ఇస్ రెస్పాన్సిబుల్.
Right. Yes, sir. Okay. I'll move to the next one. Significance: broadening protection for workers. Notional extension has a profound importance to Indian labor law for a variety of reasons. Wider coverage: it expands the protective perimeter of the Employee Compensation Act, which ensures that workers are not denied compensation based only on frivolous and the technical principle of law based on the precise boundaries of time and space. మామూలుగా ఇట్లా ట్విస్ట్ చేయొద్దని డైరెక్ట్ గా చెప్పేస్తున్నాను. Social justice: it reflects social justice perspective, which recognizes the certain risks are inherent to the journey and from work, and particularly related to travel, dictated or impacted by employment. Disincentivizing technical argumentation: it avoids an employer's ability to deny liability for an accident which simply happened outside the premises of the workplace or outside formal work hours. ఈ కేస్ కి మనం మాట్లాడింది బెస్ట్ కేస్. Relevance of work life: it recognizes contemporary realities of work. A connection to employment is not necessarily limited to the time spent carrying out the activity at the physical premises. Ultimately, notional extension is an important form of protection to ensure that protective nature of the Employees Compensation Act 1923 is realized for the workforce. Okay. In a way, it provides a proper ground for employee compensation if it happens with outside their premises.
Yeah.
Next is
sir, ఇది క్వశ్చన్ 17 రిపీటెడ్ సార్. ఇది మళ్ళీ మనం ఇండస్ట్రియల్ డిస్ప్యూట్ ఐఆర్సి ఇందాక మనం చదువుకున్నాం కదా సార్. ఐ థింక్ ఇట్స్ ద సేమ్ థింగ్. So we'll skip this.
క్వశ్చన్ 21 మీద వచ్చేసి పార్ట్ సి క్వశ్చన్ వచ్చినట్టుంది.
అది చాలా ఇంట్రెస్టింగ్ గా ఎప్పుడు కేసు అడగరు సార్. 23 ఆగస్ట్ లో అసలు ఈ కేసు గురించి అడిగేశారు డైరెక్ట్ గా.
అదే పార్ట్ సి క్వశ్చన్.
పార్ట్ సి రైట్ అబౌట్ దిస్ కేస్ అని రాశారు.
ఇది చాలా సార్లు వచ్చింది సార్ మన కేసుని.
కానీ PUDR వర్సెస్ ఇది చాలా అంటే డిఫరెంట్ కేసెస్ ఉన్నాయి సార్. దిస్ ఈజ్ అబౌట్ ఏషియన్ గేమ్స్. 1982 ఈజ్ అబౌట్ ఏషియన్ గేమ్స్. అది మీరు మనం కొంచెం జాగ్రత్త చూసుకోవాలి, ఎందుకంటే వేరేవి
చాలా కేసెస్ ఉన్నాయి.
అందుకని నేను ఏం చేశానంటే సార్, ఈ కన్ఫ్యూజన్ ఉంటదనే ఐ మేడ్ ఎ లిస్ట్.
చివర్లో మీరు పెట్టారు ఏ క్వశ్చన్ కి ఏ కేసు అన్నది.
అండ్ స్టార్టింగ్ లో కూడా పెట్టాను ఎన్ని క్వశ్చన్స్ ఎన్నిసార్లు రిపీట్ అవుతుంది.
ఫర్ ఎగ్జాంపుల్
ఇక్కడ PUDR
ఇప్పుడు ఎయిత్ PUDR is 1521 క్వశ్చన్ serial number 8.
So let's go back to this. So basically this case was about Asian Games, sir.
Yes.
So basically a public interest litigation was filed with People's Union of Democratic Rights. People's Union of Democratic Rights.
Yes.
The construction of stadiums and facilities for 1982 Asian Games involved employment of thousands of labor and contractors. A public interest litigation was filed after the survey revealed the workers were being paid wages below the prescribed minimum, denied statutory entitlements, weekly holidays, overtime wages, maternity benefit, and basic pay for workplace safety measures. So they said that it is violating fundamental rights, Article 14, 21 and 23. So same manamu facts we have listed it like FIRAC ఉంటుంది కదా, FIRAC analysis.
FIRAC, yeah.
Issues ended up whether employment as a contractors where workers are paid less than is called forced labor, whether the government can avoid liability of constitutional violation by delegating work to private contractors, whether failure to enforce labor laws in such project violates Article 14, 21 and 23. So we have listed the articles. Article 23 prohibits forced labor. Minimum wages act mandates minimum payment. Article 21 right to live with dignity beyond just mere existence, animal and resident. State accountability principle. The government cannot escape constitutional duties by engaging private agencies. ఇవన్నీ మనం ఇందాక చదువుకున్నాము సార్, చాలా కేసులు ఉన్నాయి కదా. మస్టర్ రోల్ ఒకటి ఉంది, అండ్ లేబర్ వెల్ఫేర్ స్టాట్యూట్స్. Contract Labor Regulation Act aim to ensure that even indirect employment respects workers' rights. So application entity, you apply all these Article 21, 23, and then you are saying that the Supreme Court broadened the interpretation of forced labor. It stated that workers accepting low wages below poverty is a victim of forced labor under Article 23. Court rejected the government's defense. They are contractors and it emphasized state responsibility is not delegable when public projects are involved. So conclusion ఏంటంటే the court declared that non-payment of wages is considered forced labor. State is liable. All statutory benefits under labor laws must be enforced. Labor fundamental rights of the poor and vulnerable groups must be proactively protected. The case is a landmark linking the labor rights with constitutional rights and expanding the horizon of public interest litigation for socio-economic justices in India. ఇది సార్ ఇన్ స్టోరీ. సో PUDR ఫస్ట్ టైం అడిగినట్టున్నారు ఒక కేసు,
కంప్లీట్ కేసు
జస్ట్ ఇలాగే అడిగారు. PUDR వర్సెస్ యూనియన్ ఆఫ్ ఇండియా AIR 1982 కేసు గురించి రాయండి.
సో 1982 కేసెస్ అన్ని కొంచెం ఒకసారి చూసుకుంటే దెన్ ఇట్ విల్ హెల్ప్.
కరెక్ట్. అండ్ దెన్ మినిమం వేజెస్ సార్ మీరు చదువుతారా లేకపోతే
మనం కూడా ఒక 2-3 టైమ్స్ రిపీట్ అయినట్టు సార్.
మినిమం వేజెస్, ఈ ఫెయిర్ వేజెస్, మినిమం వేజెస్ గురించి చదివి మనం కూడా అలా అయిపోయాం. ఇది కూడా రిపీట్ అయింది సార్. ఇందాక ఫెయిర్ వేజెస్ అడిగారు. ఫస్ట్ ఏమో there was a question about all three
wages.
That was asked 3-4 times. Then fair wages it was asked 2 times. Minimum wages ఒకసారి అడిగారు, just about minimum wages.
Okay.
But I think you know. Yeah.
Minimum wages?
Sir?
Okay. The term minimum wage refers to the legally mandated lowest hourly, daily, or monthly remuneration that employees must pay to their employees for the work performed during a given period. This rate cannot be reduced by individual agreements or collective bargaining. సో నార్మల్ మన గవర్నమెంట్ డిసైడ్ చేస్తుంది కదా మినిమం వేజెస్ ఫర్ అంటే అగ్రికల్చర్ దాంట్లో కానీ ఇంకెక్కడ కన్స్ట్రక్షన్ వర్క్లో కానీ దట్ ఈస్ ద వేజ్ దే నీడ్ టు ఫాలో. Here is a breakdown of key aspects of the definition. Legally mandated minimum wage is established by law either at the national, state, or industry level. So lowest remuneration, it sets the absolute floor for wages. Employees cannot legally pay less than this amount. Hourly, daily, or monthly. Minimum wages can be fixed based on different time periods of work performed. It is the compensation for the labor provided by an employee. Cannot be reduced. Individual contracts or collective agreements cannot stipulate wages lower than the minimum wage. ఇంతకన్నా తక్కువ they should not pay. This is a government decided price, either state or central government. Purpose of minimum wages, the primary aims of minimum wages are to protect workers against unduly low pay and exploitation. It ensures a basic level of income for workers, particularly those with less bargaining power. Ensure, okay, like work ఎక్కువ ఉన్నప్పుడు demand supply and follow కాకుండా they are protected with that. Ensure a minimum standard of living. It aims to provide workers with enough income to cover their basic needs like food, shelter, and clothing. Reduce poverty and inequality. By setting a wage floor, it helps to uplift the lowest paid workers and narrow the income gap. Promote fair wages and prevent injustice in wage distribution. It establishes a uniform standard for wages, ensuring fair treatment for wage earners. Contribute to economic stability. It can increase workers' purchasing power, boosting aggregate demand and economic growth. Components of minimum wage. The specific components that constitute minimum wage can vary, but they generally include basic rate of wages. This is the fundamental component of the wage. Dearness allowance or cost of living allowance. This is the additional amount paid to employee to adjust for inflation and the rising cost of living. It may be fixed or variable. Cash value of concessions. In some cases, the minimum wage may include the monetary value of essential commodities provided by employer at reduced rates. All-inclusive rate. Some jurisdiction may set a single rate that incorporates the basic wage, dearness allowance, and the cash value of the concessions. Includes of everything. It is important to remember that the exact definition and implementation of minimum wage can differ across countries and even within different regions or sectors within a country. In the context of India and the Code on Wages 2019, the definition aligns with the principle mentioned above, with the added emphasis on a national floor wage and universal applicability across all employments. Minimum wage is the lowest remuneration that an employer must legally pay to workers for the work performed, irrespective of the employer's ability to pay. It guarantees basic livelihood and prevents exploitation of labor. Nirmala Madam subject, Sarivanta.
True. Yeah.
Legal framework under Code on Wages 2019. The Code on Wages 2019 consolidates the earlier Minimum Wages Act 1948 and amalgamation of all this. Payment of Wages Act 1936, Payment of Bonus Act 1965, Equal Remuneration Act 1976. Key provisions. Section
సార్ ఇంపార్టెంట్ థింగ్ టు రిమెంబర్ ఏంటంటే సార్ ఈ 4 యాక్ట్స్ మనం గుర్తుంచుకోవాలి. కోడ్ ఆఫ్ వేజెస్ కన్సాలిడేట్ దీస్ 4 యాక్ట్స్ అనేది ఈ పేర్లు అయితే గుర్తుంచుకోవాలి సార్. అండ్ 2 వేజెస్, 1 బోనస్, 1 రెమ్యూనరేషన్. అండ్ ద సెకండ్ థింగ్, ఇంపార్టెంట్ థింగ్ ఏంటంటే సార్, సెంట్రల్ గవర్నమెంట్ ఆల్వేస్ సెట్స్ ద ఫ్లోర్ వేజ్. మనం లాస్ట్ నోట్స్ లో కూడా డిస్కస్ చేసాం. And then the minimum wage is set by either central government and state government. మళ్ళీ సెంట్రల్ గవర్నమెంట్ ఎందుకు అంటే యూనియన్ టెరిటరీస్ లో పాండిచేరిలో వాళ్లే కదా, స్టేట్ గవర్నమెంట్ లేదు కదా. సో మళ్ళీ ఆ ఫ్లోర్ వేజ్ తీసుకుని పాండిచ్చేరి గవర్నమెంట్ విల్ సే దిస్ ఈస్ ద మినిమం వేజ్.
Based on that region also it may change.
కరెక్ట్ సార్. డయ్యూ దామన్ ఉంది, అట్లా అండమాన్ ఉంది. బేస్డ్ ఆన్ ద ఏరియాస్ ఇట్ మైట్ చేంజ్. సో ఫ్లోర్ వేజ్ కన్నా కింద వెళ్ళకూడదు బేసికల్, వాళ్ళు మినిమం వేజ్ ఎంతనే పెట్టుకోవచ్చు.
సో ఇట్ ఈస్ లైక్ మెట్రోస్ లో అయితే ఎక్కువ, నాన్ మెట్రోస్ అర్బన్ రూరల్ ఏరియాస్ లో అయితే యావరేజ్ అట్లా.
సో చాలా మంది అడిగేది ఏంటంటే ఫ్లోర్ వేజ్ సెంట్రల్ గవర్నమెంట్ సెట్ చేసినాక మళ్ళీ మినిమం వేజ్ ఎందుకు సెట్ చేస్తుంది అంటే కన్ఫ్యూజన్ ఏంటంటే అక్కడ స్టేట్ గవర్నమెంట్ లేనప్పుడు సెంట్రల్ గవర్నమెంట్ చేస్తుంది. అండ్ దెన్ ఎవ్రీ 5 years రివ్యూ చేయాలి సార్ అది.
రైట్, యాక్చువల్లీ దట్ పాయింట్ ఇస్ మిస్సింగ్ హియర్. లాస్ట్ టైం మీరే చెప్పారు అనమాట.
ఇప్పుడు అది సెక్షన్ 6, 8, 9 ఉన్నాయి కదా కింద ప్రావిజన్స్ లో, వాటిలో
ఉందా? ఓకే. Section 6 empowers central government to fix a floor wage across India below which no state can set minimum wages. So central government set చేసింది అనుకుంటే below state government cannot go. Section 8, the appropriate government, central or state must fix minimum wages for employees for different sectors, skills and regions. Section 9, revision review of minimum wages must be done at intervals not exceeding 5 years. Yes, this is the point here. Section 10, factors to be considered: skill, distance, working conditions, geographical locations. Section 11, wages must be paid either in cash or partly in kind, only with government authorization. Without government authorization, they cannot pay non-cash components. Section 12, employers must pay at least the minimum wages fixed irrespective of contracts or mutual agreements. They must follow this. Factors for fixing minimum wages: cost of living, skill level, unskilled, semi-skilled, skilled or highly skilled, nature of work, location and sector, working conditions. Penalty for violation: fine up to 50,000 or imprisonment up to 3 months if minimum wages are not paid. For the subsequent offense, again within 5 years, the penalty increases to either imprisonment for up to 3 months, a fine up to 1 lakh or both. That's about it, sir. No case laws in this, but we have a lot of case laws. Yeah.
కరెక్ట్ సార్. మినిమం వేజ్ అంటే ఆల్రెడీ మనం మినిమం వేజెస్ క్వశ్చన్స్ ఉన్నాయి కదా సార్. ఎర్లియర్ క్వశ్చన్స్ లో వి హావ్ టాక్డ్ అబౌట్ లాట్ ఆఫ్ దిస్ మినిమం వేజెస్, ఫెయిర్ వేజెస్. క్వశ్చన్ 4 లో ఫర్ ఎగ్జాంపుల్ అది మోస్ట్ ఆఫ్ ద కేసెస్ వేర్ అబౌట్ మినిమం వేజెస్ ఓన్లీ. ద కోర్ట్ రూల్ ద అక్సెప్టెన్స్ P.U.D.R.V versus Union of India. Forced labor. ఇందాకే మనం చదువుకున్నాం కదా సార్ ఏషియన్ గేమ్స్ దగ్గర. ఫోర్స్ లేబర్ అన్నారు. అండ్ దెన్ ఇది వాక్యూమ్ కంపెనీ వేర్ ఇట్ వాజ్ ఆల్సో టాక్డ్ అబౌట్ ఫేర్ వేజెస్ ఎలా ఇవ్వాలి అండ్ అదే సార్. సో షల్ వి ప్రొసీడ్ ఆర్ డూ ఇట్ టుమారో?
లెట్స్ డూ ఇట్ టుమారో సార్, ఎందుకంటే మనకు ఇవాళ కోరం కూడా ఎక్కువ లేరు కదా.
అవును, కొంచెం అందరూ ఉంటే కొంచెం ఇంట్రెస్టింగ్ గా ఉంటది డిస్కస్,
అంటే డిస్కషన్ కూడా ఎక్కువ అవుతుంటది కదా మనకు.
అదే సార్. అదే రేపు వస్తారో లేదో మరి, అసలే లాంగ్ వీకెండ్ అందరికి.
అసలు లాంగ్ వీకెండ్ ఫ్రీ